All right, let's get right into it. This is a story about how a really simple request for some CCTV footage after a traffic accident just blew up. It spiraled into this massive multi-year fight that put one citizen up against a national data protection agency. And it raises some pretty serious questions about our data rights, about accountability, and what happens when the very system designed to protect you seems to let you down. So you really got to pay attention to the dates here because everything hinges on this timeline. A citizen has an accident, he confirms there's CCTV footage. 4 days later, on April 17th, he asks for it verbally and gets turned down. So he does the right thing and sends a formal written request on April 25th. But here's the kicker. The footage gets automatically deleted on April 30th. That's just 5 days later, and, this is absolutely crucial, it's 2 days before the organization officially refuses his request on May 2nd. This sequence of events, right here, becomes the flashpoint for this entire dispute. So the citizen files a complaint, and the whole thing lands on the desk of Singapore's Personal Data Protection Commission, the PDPC. And after months of digging in, what did they actually decide? Well, this is where it gets really interesting. The PDPC came back with 2 core rulings that just left the complainant floored. First, they said, hey, no rules were broken when the footage was deleted. And their reason? Because the data was wiped on April 30th, before the formal refusal on May 2nd. For them, the timing was everything. And second, they ruled the footage wasn't even personal data to begin with because you couldn't clearly see the person's face. These 2 decisions, right here, set the stage for a years-long challenge. Now, the complainant didn't just disagree with the ruling. Nope. He took their decision and systematically took it apart. He put together this incredibly detailed list of what he argued were just critical errors, both in how the PDPC investigated and in their legal thinking. And here it is. This is the heart of his entire argument. This fact sheet became the foundation for his appeal, and it's basically a point-by-point takedown of what he calls a flawed investigation. He argues they got the very definition of personal data wrong, they created a loophole that lets organizations just wait for data to be deleted, and they completely ignored his first verbal request, which would have changed the whole timeline. This document turned his personal quest for footage into a public case for fixing the system. Okay, so let's break down that first big alleged flaw. What even is personal data? The PDPC's view was pretty simple. No clear face, not personal data. But the complainant fired back, saying, wait a minute, the law talks about being identifiable, and he pointed out that the security guards on site had already identified him from that exact footage in the real world. So his question was, if I'm identifiable in reality, how can the data not be personal? It's a really good question, right? And this brings us to what he called the Section 22A loophole. This is so important. The PDP's whole case rested on those dates. Because the footage was deleted before the formal refusal letter was sent, they said everything was fine. But think about what that means. The complainant argued this basically creates a playbook for any organization to legally get out of giving you your data. All they have to do is wait. Just wait for the automatic deletion to happen and then send the refusal. A pretty serious loophole, if you ask me. And it didn't stop there. The list of alleged flaws just kept growing. He argued the PDPC ignored other data retention laws and that they just accepted the building's claim of a 17-day retention policy without asking for any proof. He even claimed they created another weird loophole by treating the building management and their agent as 2 separate companies. And get this, he says that when he challenged them using their own published guidelines, they just said the guidelines were incorrect and then stopped communicating. This whole thing wasn't just about legal jargon and technicalities. The complainant's documents also paint a picture of a really frustrating communication breakdown. We're talking about a story of long delays, unanswered questions, and just the feeling of being completely stonewalled. So after he escalated his very detailed concerns up the chain to the PDPC's parent agency, IMDA, what did he get back? For 7 whole months, nothing. Just radio silence. Apparently, it wasn't until the Public Service Division got involved that he finally received a response. This one quote from his letter just says it all, doesn't it? The result was opacity, not clarity. He felt he was being met with these blurry lines between agencies and just circular logic. Instead of getting answers, he felt like he was only getting more confusion. And according to his email records, a really frustrating pattern emerged. The PDPC would allegedly introduce a new reason for saying no, and when he would write back to clarify something or correct what he saw as a mistake, poof, they just go silent. This is what led him to believe the agency was acting more like a lawyer for the organization than an impartial investigator. All right, let's pull the lens back for a second and look at the bigger picture. How does this one individual's documented experience stack up against the nation's own stated goals for data governance and public trust? Here we have the official promise, right from Parliament. The data protection framework is reviewed all the time to make sure it's working. The whole spirit of the law is that safeguards are in place and that you can't just destroy records to avoid giving someone access. I mean, that's supposed to be a criminal offense. At another event, a minister calls for greater clarity in how data is governed. Yet the person at the center of the story described his experience as the complete opposite: opacity, confusion, and blurred lines. The government has also warned that laws by themselves aren't enough to maintain trust, and they've talked about the cracks in our infrastructure of fact. Well, for the citizen in this case, the PDPC's ruling felt like one of those very cracks opening right beneath his feet. And finally, there's this promise that our digital future has to be for everyone. The complainant argued that everyone has to include regular citizens just trying to use the lawful process, but he felt his experience actually discouraged that kind of civic engagement. And this brings us to the core question he eventually put in an email directly to the Prime Minister. It's a powerful one. If Parliament and the ministers say the law is strong and requires data to be saved, but the agency in charge of enforcing it makes a ruling that seems to allow that data to be deleted without any consequences, who is right? Ultimately, this whole case, which all started from a simple traffic accident, leaves all of us with a much, much bigger question. It's now trust, it's about accountability, and it's about the real-world application of our laws. When the promise of the law clashes so hard with someone's lived reality, who is responsible for bridging that gap?